Well, hello, Lurk Armstrong, your real estate agent and advocate here. I'm excited. We are still in landlord tenant land. We are still in landlord tenant land. So while we do all these things on YouTube, we make sure that we take care of our housekeeping. We do our YouTube responsibilities. We like, share, and subscribe. It doesn't cost us any money. And even though you are sweeping the floor and you are washing the dishes, guess what? This is free and it doesn't even require much. Just click, 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 like, share, and subscribe. Thanks all so much. We're going to get back into court. Let's see here. Where were we? We were at Judge Kristen Simpson, I believe. Is her court? Yes. And she has her courtroom with her landlord tenant court docket for the day. We were able to learn a couple of things about filing, different filing process for Michigan, and making sure that you are filing your notice to quit so that your tenant can go and get relief if they so qualify. At least that was what Ms. Smith said needed to happen for her, that she needed an official notice to quit in order to look for relief, but she still didn't get it. So we do wish her well, her and Ms. Mendez. And we shall see now Judge Simpson, D54A courtroom. What's on the docket next? Let me know. Can you hear me? Can you see me?
Bridge Apartments versus Devontae Leggett and Autumn Powell. File number is 23-00570.
Autumn and Devontae, they're up.
Appearance for the record, counsel.
Yes, Christopher Asphalt for the plaintiff.
Okay, and then we have both defendants present via Zoom. Today was the date set for a hearing. How are we proceeding, counsel?
Your Honor, we have the terms of a consent judgment that I'd like to put on the record.
To proceed.
All right, the parties are in agreement that there's $3,860 due and owing at this time, including court costs.
I want Chris to be careful because the last case he said we had a consent judgment, and no, not quite. So I hope he knows for sure that Autumn and Devontae are conceding to this actual judgment, that they do in fact do consent.
The plaintiffs will pay $800 by May 26th, $3,060 by June 9th, and June's rent and June's late fee by June 23rd. If the parties fail to make any of those payments, then plaintiff can file for an order of eviction. Both defendants have given me permission to sign their name to a consent judgment with those terms.
Lovely. I like this. They have actually gone into a payment schedule. If you don't have, I think Sarah's one of them. Sounds like they say DHS, maybe might be another program, and maybe there's another program outside of them that are providing these intervention services and emergency services to help the tenant stay into the property. If you don't have that, where they will pay all the arrears, to have a payment schedule that your landlord is agreement to, I appreciate that. I am grateful for those landlord. This particular landlord that Christopher is Mr. Asphalt, I believe is the pronunciation, that he is representing in this matter, that they are in fact allowing Autumn and Devontae to put on a payment schedule, to make payments, to catch up, and it's reasonable. It seems like it's all in the month of June. It's a reasonable time frame, so this is cool. I like it.
Okay, so you said it was $3,860 plus court costs?
No, that's including court costs, Your Honor.
Okay,
I'm going to break it down.
Nope, that's fine. And then there is a payment arrangement. They're going to pay $800 by May 26th?
Yes.
What are they paying by June 9th?
$3,060 by June 9th.
$3,060, okay.
And then June's rent, June's late fee by June 23rd.
Okay, Ms. Powell and Mr. Leggett, is that accurate?
Yes.
Yes.
Okay, so you want to waive your rights in order to enter into consent judgment today?
Yes.
Yes.
Okay, so you have a right in this matter to be represented by counsel. You were advised of that right back on April 19th. Are you waiving your rights today, Mr. Leggett?
Yes.
Yes.
Okay, thank you. And so you also have the right to proceed to a trial, or you could have had your hearing today. Are you waiving your right to hearing and or trial in order to enter into a consent judgment?
Yes.
Okay, so you're agreeing to pay the total amount of $3,860, which is the rent to retain. You agree to pay $800 by May 26th. You agree to pay $3,060 by June 9th, and then you're gonna pay June rent and late fees by June 23rd, correct?
Yes.
Yes.
Okay. Anybody threatening you to get you to enter into consent judgment and waive your rights today?
No.
Has there been any promises made to you in exchange for waiving your rights?
No.
Okay, Ms. Powell,
Interesting enough, she's allowing them to answer together. She did try to get Mr. Devontae Leggette's answer separate, but they both answered at the same time. But anyway, the record is clear. Neither of them are contradicting the other.
I didn't hear if anybody was threatening you. I didn't hear your answer.
No.
Okay. You have 3 business days from today. If you leave the courtroom and you realize you misunderstood any of the.
No, what? Because I believe the question is, you concede that no one is threatening you. I thought that was the question. So no, you don't concede, or no, no one's threatening.
Rights that you just waived, you can return to the court and request to have this
I
judgment
mean,
set aside. We can set this matter for a hearing, okay?
Okay.
Lastly, are you both giving Mr. Asphalt permission to sign your name to the consent judgment?
Yes.
Yes.
Okay. Do you have any questions for the court?
No, I do not.
Any additional matters for the record, counsel?
No.
Okay, you're all set. Thank you.
Thank you.
All right, we waited so long because we waited for the last video. If you guys saw the video from the other day, we waited for that video to see the Autumn and Devontae to hear their case, and they had a consent judgment. It was quick, fast, and easy to hear it. So that's the conclusion for them. Hopefully that will be well. I did get to see a payment schedule being accepted by a landlord, so that's a little new. We haven't seen that, though I know that this happens, but I haven't seen it on a court level. You know, we have the agreement off the books, if you will, not necessarily before the court. This is the time where the court is taking notice of the particular agreement and lodging it and keeping record, and it's great. I hope that they're able to abide by all of those agreement dates. Sounds like the second date is like the full amount. So there's an $800 deposit, $300,000 in a week or two later, and then the final or the payment for the current month, and then that will take them in and bring them current. So hopefully it works out.
Pretty, Judge.
What'd she say?
Was she pretty, Judge?
She's a pretty judge. Okay. She is. Judges are not all ugly. I mean, well, I don't know any ugly.
Patricia Lewis did not appear, so you can submit default.
Very well, Judge.
Okay, someone missed their date.
And let's see.
They're getting a default. Not that big of.
Joseph Cohn failed to appear.
All right, so we're into the FTAs.
No, that's her.
Not important. We don't learn much from that, other than if you don't show up, you get a default.
Okay, and Miss Till, you're here with Miss Jackson.
Correct, Your Honor.
You need to speak to.
Sorry, Miss Jackson. Hey. Oh, never mind.
Mr. Asloff again.
If I could, please.
Okay. He's in room 1. I'll just add you to room 1.
Okay, perfect.
Okay, as we learned previously, judge wants parties to consult prior to the case to see if they can get a mediation. Oh, Miss Deborah's back.
He must be out there soon. Can someone let him know that we're ready?
Poor Deborah. Deborah, we were done with you. I think this is Deborah. I'm not sure. Her audio had issues the last time towards the end, so I'm not sure if she actually heard the dissemination of the case, but the case has been decided upon and her presence is no longer needed, but she keeps popping back up. Maybe she's enjoying court as much as I am. Oh, we do not, Miss Jackson. No, Miss Jackson, we don't smoke in court, Miss Jackson. Judge Middleton taught us that. There's no smoking in court. Uh-oh, I'm pressing the wrong button. Sorry, guys. Your computer's not acting up. I've just sped them up, so here all day during the silence in between time. Looks like Miss Jackson is trying to correct hearing or her audio, but yet the court is not, so there's no audible to be, no audio to hear. Oh, this is a different lady. Okay, so maybe the other lady was smoking and she's not Miss Jackson, but well, there's no smoking in court. So don't give her the mic. Don't give her the phone. There's no smoking in court. Okay, so just coming back to the bench. We have
We're ready on Chastity Edwards.
That's right.
Okay.
Hello.
Okay, you can start your video, please.
not you, Miss Jackson.
Somebody please understand.
Miss Jackson. Help Miss Jackson.
I don't know if y'all can see me, but I started my vehicle, I think.
I can see you. Give me just a moment.
I don't know if y'all can see me, but I started my vehicle, I think.
Awesome. Oh, you too. Okay, we can see you. Okay, today we're on the record in the matter of Edgewood Lansing Limited versus Chastity Edwards, file number 22-00489 LT. Council appearance.
Good afternoon, Your Honor. Brian Lum on behalf of the plaintiff.
Okay, and Ms. Edwards is present via Zoom. Today was the date set for a hearing for non-payment of rent. Could you all come to a resolution?
Yes, Your Honor. We
Getting photobombed by my youngest. What's up with that?
agree to a conditional dismissal.
Okay, what are the terms? Are
No,
you still working on it?
we have Miss Edwards has until June 30th to pay her arrearages, which is $1,788.05 in rent, $243.77 in court costs and fees, and
You guys, thankfully she doesn't have a high arrears in terms of her rent. Looks like she has less than $2,000, whereas we've heard $12,000 last time. Like I forget the name of the litigant's name at this point. And then we've heard $6,000, $3,000. So she has less than $2,000. So that's good. She's been managing her payments and keeping a mitigation of her damages, and that's good. But another thing I would suggest, because I can't give you advice, right? You're not my client. You have to sign an agreement with me to be my client. This is all commentary, my opinion, and just, a suggestion. But I would also suggest that as a tenant, you work these type of payment arrangements out with your landlord a little earlier so that you don't have to go to court, because now you're paying court fees. Essentially, it's $200 some odd extra in court fees that could in fact go towards next month's rent, could go towards, food and all the other lovely things we need to survive. So be mindful of working things out, being communicative with your creditors, inclusive of your landlord, so that you don't have to incur unnecessary late fees, or in this case, court fees.
$741.35 in utilities and late fees. The total is $2,773.17. And she would also have to pay her June rent and utilities by June 30th. as long as she pays that, the case would be dismissed. If not, we would ask to immediately file any eviction order without further hearing. And partial payment will not stop the issuance of an order of eviction.
Okay, you have that written out. Okay, Ms. Edwards, did you hear what was stated by Mr. Lum on the record?
Yes, ma'am.
Okay, and are you entering into a conditional dismissal with the agreement to pay past due rent in the amount of $1,788.05 plus court costs in the amount of $243.77? Says other money due, $741.35. What's that for?
That's utility costs and late fees.
Okay, that includes utilities and late fees. And then for a total.
So I would like a Michigan attorney or someone to speak to this, put it in the comments, let me know. But it sounds to me to be more favorable to go into a conditional dismissal versus a consent to judgment. And the reason why I say this is a conditional dismissal dismisses the case under certain conditions. I think I would advocate for that more so than just having a consent judgment, because the judgment goes against you because you consent to it. And I would believe that that would be still discoverable when it comes time to going to your next location, because when they do a background check, I would believe that type of judgment would still be discoverable, just like any other judgment that comes up against you.
Amount due
Let me know what you think.
$2,773.17, and you'll pay that before June 30th. That's correct?
Yes, ma'am.
Okay, you're not driving, are you?
I'm in the car, but I'm not the one driving.
Okay, very good. Okay, and so you also, also agree that you will pay June's rent and utilities and all arrearages by June 30th, 2023 as well, correct?
Yes, ma'am.
And you understand that partial performance or partial payment of this agreement will not satisfy the conditional dismissal. You understand that? You have to pay in full.
Yes, ma'am. Yes, ma'am.
Okay. So before you can enter into this agreement, you have to waive a couple of rights. You have the right to be represented by an attorney at this hearing. You were noticed of that right back on April 12th at your pretrial. So are you waiving your right to be represented today?
Yes, ma'am.
Okay, and then you also have the right to have a trial in this matter. Are you waiving your right to jury trial in order to enter into conditional dismissal?
Yes, ma'am.
Okay. Anybody promising you anything or threatening you to get you to waive your rights?
No, ma'am.
Okay. You have 3 business days from today. If once you leave the courtroom, you realize you misunderstood any of the rights that you're waiving, you can request to have this dismissal set aside. We'll set this matter for a hearing for you, okay? She looks like she might be frozen. And that's why you can't be moving. Can you hear me?
I don't think she can hear me. Can you hear me?
I can hear you, but because you're in a moving vehicle and not stationary, your signal is going in and out.
Can you pull over there and park for like 5 seconds?
Which is the reason why they say upright position, stationary position is the appropriate way to appear for court.
Okay, Your Honor, my friend is parking.
Okay. Okay. So the last thing I stated was that you can request to have this dismissal set aside and we'll set it for a hearing. If you leave the court and within the next 3 days, business days, that is, you realize you misunderstood the rights that you had to waive in order to enter into this agreement, okay?
Yes, ma'am.
Okay. Lastly, do we have your permission to sign your name to this agreement?
Yes, ma'am.
Do you have any questions for the court, ma'am?
No, I don't.
Okay, you're all set. Thank you.
Thank you.
Thank you, Mr. Law. Let's see, 2:30. Could you see Dennis Morrow or Joyce Morrow today? Maybe in the hallway? No, we're not. They're not here? Yeah, attorney here for Trot Law?
Yes, Your Honor.
Okay, no one has appeared on behalf of, let's see, am I doing the right one? Yes, on behalf of Dennis Morrow or Joyce Morrow, so you can submit default judgment.
Okay, Your Honor. Thank you very much.
Thank you, have a good one.
You too. Bye.
Are we ready on Ms. Jackson?
Can I be placed in a breakout room with Ms. Jackson? I believe we're fairly close.
Okay, I'll add her to room 1.
Thank you.
What's your name again, ma'am? Okay, do you have a device that you can get on Zoom with?
I don't know if I can get on Zoom.
Okay, we'll get you on our iPad in just a moment. Mr. Aswell, we have Ms. Sleeper here.
Your Honor, I'm sorry, can you hear me good? Or
I can hear you, yes.
okay, on the Dennis Morrow case, I just want to confirm that it's 10 days, writ to enter in 10 days.
Yep, the writ date is the 5th of June.
Okay, thank you, Your Honor.
Thank you.
Meeting room? Or it left the main meeting? Appeared in. Your Honor, Miss Jackson has not appeared in the breakout room. Has she left the meeting room? Or left the main meeting?
Okay, but Miss Susan, no, 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 no. We gotta sit up.
She's not there. I see someone logging in. It might be your other client, Scally.
Oh, okay.
You're gonna probably want to advise them that they will not lay down in my Zoom court today.
I certainly will do that if that is in fact her.
Yes, please let your
Miss Scally,
Yeah,
you need to be sitting up in Judge Simmons' courtroom, okay?
I'm sorry. I was just checking to make sure that things were going the way my attorney had said they would.
You need to sit up to do that. You need to show proper respect to Judge Simmons in this
You're in
courtroom.
court.
Thank you.
You are in court.
I'm so sorry. I was not aware I was even on camera.
You're fine. You just need to sit up. You are all set. The consent order was entered. So you're all set. You didn't need to log on to Zoom today.
Oh, okay. I'm sorry. I'm sorry, Your Honor. I didn't mean any disrespect.
Thank you, Miss Scally. You can go ahead and log off.
Okay, thank you.
Does Your Honor accept? Your Honor says, there's no need to have a communication with me. You and your attorney can speak. Ms. Scally needs help. There we go. Good job. She did it. She did it. But remember that Zoom has this funny thing. Sometimes it depends on how someone sets it up, that when you get on Zoom, you're unmuted and your camera is checked. so you're visible. Or it could be checked to a place where you're not visible and you're not unmuted. So pay attention to the prompts. Are you muted? Is your camera on? And make sure your environment is conducive for court, because as soon as you come on, you're before the judge. You don't want to be derobed in front of the judge.
Judge Simmons?
Laying down in front of the judge.
Yes.
I just received an email. I'm so sorry for telling Miss Scally to log off. I had just received an email that you wanted this placed on the record.
Correct. She has to make sure, I have to make sure she is advised of her rights.
Oh, okay. I did advise her of her rights. Do you want me to have her log in again?
Okay, it looks like this was already entered though.
It's not anything, it's just-
Oh, okay, sounds good. Yes, if she can log back in, I can go over her rights with her. Thank you.
Okay, perfect. Thank you.
And that's just another form of housekeeping as well for the court. The court can definitely receive the fact that the attorney advised their client of their rights, but the court is saying, I need on the record, the court has advised of rights, because when we get to the next hearing, if she waives her rights or whatever, she's had notice. And sometimes the advisement of the rights coming into court and you're told of all your rights. There's like, when you have a judgment, you have the 3 days, I guess it is. So you have some time that you can go to an attorney and say, well, what did I waive my rights to for the jury trial? What did I waive my rights to, for the consent to judgment? What does that mean? I entered into this judgment. I consent that I owe this money, but I don't want this on my record. Now you can have these
Okay,
other.
are we ready with Ms. Sleeper?
You can come back and say, wait,
Judge.
I don't want to waive my rights after all. And you do that within like
We're on
3
the record
days.
in the matter of Woodbridge Apartments versus Dixie Sleeper. File number is
So-
23-
Sorry, they were quiet first. You say, I don't want to waive my rights. After all, Your Honor, I have better advice as to what my rights are more in depthly. I didn't understand them the first time. I understand them now. And then I do want to evoke my right. I want to have the right to jury trial or bench trial, a hearing. I want Your Honor to hear me. Instead of having a consent judgment, I want a conditional judgment, a conditional dismissal. I'm sorry. I want a conditional dismissal. One of the things I was saying, I had a question earlier about. That is why the court needs to conduct the understanding of the rights, the waiver of rights, because there's a time tickler, not just the officer of the court being the defense attorney or
00571 LT.
tenant attorney, party attorney.
Christopher Asphalt for the plaintiff.
Okay. And then Ms. Sleeper is present in the courtroom. You can come up to the table there, ma'am. Today is the date and the time that was set for a hearing. The parties met privately. Did you come to a resolution, Mr. Asphalt?
Yes, Judge, we have the terms of a consent judgment I'd like to put on the record.
You can proceed.
The parties are in agreement that there's $3,251 due and owing. The defendant shall pay that amount on or before June 5th. If for some reason she fails to make that payment, then plaintiff can move for an order of eviction. The defendant agrees that gives her consent that I can sign her name to a consent judgment with those terms.
Okay. And that includes court costs?
Yes.
Okay, ma'am, that's accurate? Yes. Okay. Do you understand that you have the right to be represented by counsel during these proceedings? Yes. You understand also that you have the right to have a jury trial in this matter? Yes. Okay, and you're willing to waive both of those rights in order to enter into a consent judgment? Yes. Okay, so you're entering consent judgment to pay the amount of rent due $3,251, which includes court costs. You're gonna pay that or vacate the property by June 5th, 2023? Yes. Is anybody threatening you or making any promises to you to get you to waive your rights today? No. Okay. Yeah.
Okay, Ms. Scally needs a breakout room. She needs an understanding. Okay, she got her light on now. When you're in court, you have to be seen as if you could be seen at the podium to come into court. So if you're on Zoom in court, have your lights on so we can see your face.
3
She fixed
business
it,
days
though.
from
Good
today.
job.
If
Good
you
job, Ms.
leave
Kelly.
here,
We can see you
determine
now.
you misunderstood any of the rights that we just discussed, you can return to the court. You can request to have this judgment set aside, and then we'll set this for a hearing, okay? Do you have any questions?
So 3 business days, that would include next Tuesday.
Tuesday, because Monday's a holiday.
That would be the 3rd day.
Correct. Okay, no problem. Okay, and so lastly, did you give Mr. Asphalt permission to sign the consent judgment on your behalf?
Yes.
Okay, do you have any other questions?
No.
Okay, well then you're all set, thank you. Okay, Ms. Till, your client is back on.
Thank you, Your Honor.
No problem. We're on the record in the matter of Dean Heritage versus Suzanne Scally. File number is 23-00581 LT. Ms. Scally, we just had you log back on because we did have a consent judgment here, and it states that you are agreeing to pay the amount of $3,812.96 by June 5th or vacate the property by that date. Is that accurate?
That is correct.
Okay, and that includes other money due, some costs for court costs. You understand that?
I do, and I would like to pay the court costs first. Is that all right? Or
Okay, you probably-
is it all together?
It's all together. It's all gonna go to the plaintiff, okay?
Okay.
Okay, so I just want to make sure you understand the rights that you have to give up in order to enter into consent judgment. So you have the right to be represented by counsel or represented by legal services, so you don't have to waive that right. But you have the right in this matter to have a trial, and you could have had a jury trial. Do you want to waive your right to a trial in order to enter into consent judgment?
Yes, I do.
Okay, anybody promising you anything or threatening you to get you to enter into consent judgment?
No, ma'am.
Okay, so this judgment will enter today. You have 3 days from today to return, 3 business days that is, to return to the court. If once you leave here, you realize you misunderstood your right that you just waived in order to enter consent judgment, you can request to have this judgment set aside and we'll set it for trial, okay?
Yes, ma'am. Thank you very much.
Thank you, you're all set.
Thank you.
Okay. Did Ms. Jackson log back in?
Just sweetie.
Or who was?
Like, I don't want to miss. I thank you, Miss Your Honor. Bless her heart.
I have not seen Miss Jackson, Your
Oh, that
Honor.
was Keani Kemp. Keani Kemp,
Yes.
your matter was dismissed, so you're all set.
Okay, thank you.
You're welcome. Do you have contact information for Ms. Jackson?
I do. I'll give her a call right quick, Your Honor.
Okay.
They messed Miss Jackson up. They were trying to put her in a breakout room.
Okay.
She looked of a certain
Donovan
age.
was supposed to appear in person. She's not done that.
Everybody else in the household was trying to fix the phone for her. You messed her up. You put her in the breakout room. She's lost in the ether. Got to find her on the internet.
Okay, Mr. Asphalt, you can submit default.
Sorry, Miss
I
Jackson.
will, Judge. Thank you.
I was just told to hop on for the Dean versus Suzanne Scally.
Oh, okay. We just handled it. I just went over her rights. You had already signed the consent judgment. Or
Okay.
Someone from your office did, so you're all set.
Okay, I just wanted to check, make sure everything was good.
Thank you.
Thank you.
Look at court. We get to see how things are coming in, going out. You got attorneys logging in, logging off, in and out, in and out. A lot of activity, taking care of the business of court. But, oh, poor baby, she's stretching. It's a long day, right? A lot to do. Well, taking into those considerations for what you have to handle in court, but they're simple. A great deal of them are simple. Not so many aspects are that contentious. We don't have Miss Blair all over the place. We only got one Miss Blair, okay? She cannot be duplicated. One litigant in Michigan that's got everybody duped. It's Miss Blair. Except for Judge Middleton. He is not duped, okay? He is like, no, I'm not fooled by this. Let's see, what's Rochelle doing? Miss Rochelle, get stationary, baby. Sit down, be in an upright position.
Where's those headphones?
Okay, she getting in her position. Very nice. Zoom court is so nice. Look at the lovely painting on the wall. Oh no, she got up again. Okay. Gotta sit down, baby girl. We gotta sit down. In an upright position. Oh, we're going up the stairs. Lord have mercy. And this is what I mean. Like, there was one lady in there, the phone was like right towards her stomach area, and her we in the bathroom now. And her uppities were uppity. It's like, oh, not for court. We in court. We got her. We're doing our hair in court. Okay, we don't do our hair in court. Judge Manning taught us that we don't care.
Mommy, come here.
Are in the prison. You cannot be playing with your hair in court.
Yes. I can my camera.
Judge Manning.
I can find my nuts. Yeah, a small piece. The big piece.
At least she's not using the bathroom. Praise the Lord. Praise the Lord for miracles that He provides us. Oh, baby, hey, baby. We got babies helping mama fix the hair. Okay, well, I do that too. How my babies help me fix my hair. It's not in court. Just okay. See, the judge has left the bench. She don't see all this. Hopefully, we will get Miss Rochelle Walker in position where she is upright and prepared and ready for court. Uh-oh, did she lose? And now she lost connectivity. We done seen all your house, the bathroom, the stairs. Okay. Come on, y'all. We in court. Remember, you are in court when you.
Ms. Toad, I don't know what happened to Miss Jackson, but I can reset this until the 7th.
Okay, I apologize, Your Honor. I've been trying to troubleshoot with them. I haven't been successful. Do you want them to come in person next time, or if I'm able to get them on Zoom? Okay.
Your Honor, I guess just for the record, I'm going to object. This is at the last hearing, I thought a default judgment had been granted on April 19th.
Not on this one. No, I have here April 12th. It was reset to the 19th. Because they were serviced by attachment, and then I guess no one appeared. And then I was told Mr. McCanny was deceased, but I don't see where there was a default.
That's what my notes say, is that all defendants failed to appear, and that I requested and a default was granted, but.
Nope, I see here, hearing set May 24th at 2:45. And I was told the pretrial that Mr. McCanny was deceased by Miss Jackson.
Okay.
Your Honor, what time was that June 7th reset date?
2:45.
Thank you, Your Honor. And again, I apologize.
No problem. Thank you.
All right, thank you, Your Honor.
I believe that's all my files too, Your Honor. Have a good day.
Same to you. And so we're just waiting for Rosemary and Walker.
So I guess that's the defense attorney's life. We apologize, Your Honor. We apologize. I apologize. It's not her fault. She tried to troubleshoot it. For whatever reason, they can't get on. Jackson can't get on. Christopher's upset. He believed that they had a default judgment last time, and we're getting another continuance. Continue. And as you can tell, the continuance, further in the future. I think this might be it because they're waiting for a particular litigant to appear that may or may not do so. So let's see what we have here. Ms. Walker is back. Right, Ms. Walker? She is stationary. We've been able to see her beautiful home. Love her decor. I love the hat. In the background, this picture here, I like that a lot. Okay. Now, Judge Brian would not be okay with the glasses on the top of the head, but okay. That's not proper decorum in her court. Oh, now, okay, baby, this is.
You can be seated. Okay.
So another thing for everyone to remember, when you are on Zoom court and you are looking and you're waiting for the judge, there's this world out here. We're out here. See, we're here. We're on the YouTubes and we are law nerds, okay? And we're out here. We can see you. Don't just upright yourself for the judge. Be careful with that camera, okay, baby? Because we can see you.
On the record in the matter.
Okay. Are we gonna help Ms. Walker in the next 6 minutes?
OPP Partners versus Rochelle Walker.
Great. Lovely.
This is file number 23-00588 LT. Council appearance.
May it please the court, Mark Wasbury on behalf of plaintiff.
Okay.
Okay. Today was the date and time set for hearing. I'm not sure what this is. Did you all come to a resolution?
Yes, Your Honor, we've agreed to a conditional dismissal with a move-out date of June 30th, 2023. This was not a complaint for money, so there's no money involved with this. 4B of the form will be checked so that advised Ms. Walker that after the 30th, if she hasn't vacated, that my client could seek an order of eviction. And I would be asking for her permission to sign the conditional dismissal.
Okay, sounds good. Mr. Walker, did you hear Mr. Wasbury correctly?
Yes.
Okay, so you're entering into a conditional dismissal, meaning the case will be dismissed today upon the condition that you vacate the property no later than June 30th?
Yes.
Okay, and so you understand that you have to vacate and remove all of your items before this will be considered a full performance. Partial performance will not satisfy the conditional dismissal. You recognize that?
Yes.
Okay. And you have the right to appear with an attorney today. You were advised of that right back on April 19th. Are you waiving your right to be represented by counsel in order to move forward with this agreement?
Yes. I had set up for a jury trial. I came in, but he said he didn't get the paperwork.
Okay, that was the next right I was gonna go over, that you did have a right to demand a jury trial. But are you willing to waive your right to trial in order to enter into the conditional dismissal?
I guess.
Okay, and so, but you have to be sure because this is your right to waive. So I don't see where you filed a counter suit in this case, but
I've never been evicted before, so I don't even know none of this. My whole thing was we came to an agreement in December for me to pay $4,100, and 3 weeks later, and I paid it. And then they turned around and then they asked me to move anyways. So I didn't even understand. I wasn't late on my rent. the program that they accepted was late, not me.
What have I said? You are responsible. If you are in a program and the program is supposed to pay, they got to pay on time. They have to pay it. You're responsible for them being timely and paying in full. And when you waive your right to counsel, all this communication you're having with the judge is mute. You need to have an attorney to speak about any confusion you have so that you can be clear on what's going on and what you have a right to.
But they accepted the program because I wasn't working at the time. And so my whole thing was, why would they accept it and then turn around and disagree?
Okay. Maybe the program, they accepted it because they figured they could get their money, but the program's not paying on time. So now they're saying, no, we don't want this program because they are not timely.
Like I did something wrong, but he said it wouldn't be on my record or anything. So
Right, this is a conditional dismissal, so they're gonna dismiss the case if you vacate.
Right, it's a dismissal, not a judgment.
Okay.
So if you do
Okay,
full
so you wanna
performance.
waive your trial in order to have the case dismissed on the condition that you vacate, correct?
yes.
Okay. I don't know if I were the judge, which I'm not, she's more educated than I, more experienced than I. My opinion is, if I were the judge, I think in that scenario, in that exchange, I would have her speak to the legal aid before I have her waive her right to everything and then come back and see if she waives her right. Because I feel like the litigant, the tenant, is expressing herself, expressing her concerns and her questions, and by the judge proceeding on with the next question or confirming the factor that, no, this is not going to be on your record, it's like giving advice. Not to say that the judge is giving advice, but I feel like Ms. Walker would walk away, a layman person would walk away and feel like the judge told them this is the only recourse that they have, when maybe it is and maybe it isn't, but typically judges don't want to be in the position of giving any of the litigants advice. That's why you have an attorney for all legal advice. So
You have 3 business days from today's date.
that's my little 2
If you leave the
cents.
court and realize you misunderstood any of the rights that you just waived, you can return to the court and have a request to have.
And then there goes that disclosure that just makes it not matter anymore, right? Because you have 3 days to ponder it and tell the court, no, actually, I misspoke. I was ill-informed. I did not have proper advice. I do, in fact, do not want to waive any of my rights. And then seek legal counsel and determine if all those factors are the case. Ms. Walker clearly doesn't understand that even though there's a program that everyone's agreeing to use and to receive funds from, the landlord can, like they say, just decide not to proceed anymore with that program based upon performance. The program's performance is not timely, and consequently, it's a problem for the landlord. So they're moving forward with eviction, but they're doing it in a way that it's a dismissal, so it doesn't go against the record as long as she does full performance, which the judge has already informed her that full performance is just her moving out with all of her things, not just self and leaving anything behind. Don't leave the dustpan behind. Don't leave nothing behind. Take all of your stuff out. And especially the bulky items, because if you can't move it and you're making your landlord move it, you're still paying for the move because they're just going to deduct it and put it a judgment against you or damage cost against your security deposit. So I feel really bad for Ms. Walker in this situation. I understand her thought process, like, she's paid what was necessary to pay to stay, and now we're in this conundrum months later based upon someone else's actions, not her own in her mind. And so it's unfortunate, and she clearly is taking good care of the property. We've noticed it's nice and clean and orderly, so Ms. Walker is seemingly doing well by the property, other than the fact that she can't get the payment in on time.
The dismissal set aside, we will set it for a hearing, okay?
Okay.
Did you give Mr. Rosary permission to sign your name to the conditional dismissal?
Yes.
Okay, do you have any questions for the court at this time?
No, If it went to trial, is it a possibility that I could win?
I couldn't tell you. I don't know anything about the case. It would be like me telling you if I go and play the lottery today, is it possible that I could win? I don't know. I don't know what the numbers are. But I could tell you that conditional dismissal is a great offer because you lose the chance of having something get on your record.
Nah, I know.
So the judge may not have advised you as to what is best for you, but she has definitely advised me and answered my question. Because my thought process was, if I was going to enter into any type of agreement, my agreement would be to advocate for the conditional dismissal versus the consent judgment. And that's under the circumstance of if you're not going to be able to pay it. I think that the consent judgment is entered into as an only option, maybe. No. Yeah, so I would go for the conditional dismissal. That's the one I would want over the judgment, because I don't want the judgment on my record.
You don't want your record, your credit screwed up for something to make a principal argument, at least what you think could be a principal argument. You may find out the jury didn't agree with you. I don't know.
That's true. Okay. Well, it was just like I've been looking for months, even because I planned on moving out anyway in July. I just can't find anything safe for my busy 18-year-old. I don't want to put him in no way where he could enter into the world. I don't have my other two sons out of jail system. I'm trying to keep him out too. So I'm just looking for somewhere safe to take him. But
I understand that. Well, hopefully you'll have you have a little bit more than a month. You'll have time to find a safe, suitable place so that you and your son can reside.
Okay, thank you.
You're welcome. Do you have any other questions?
No.
Any additional matters for the record?
No, thank you, Judge.
Okay, you're all set, Ms. Walker. Good luck to you.
Thank you.
Oh, how sweet. Such sweetness at the end. That's a good way to end it, right? On a cute, sweet note. I feel a little bad for Madam Walker. She clearly doesn't feel like this is a good timing for her, maybe. Maybe that's the way to express it, because it sounds like she was trying to make arrangements to vacate in short order. They want her out by June 30th, and I believe she expressed she was already looking to be out by July, but she wants somewhere safe, away from certain activity that would potentially affect the decisions that her children make, and that's a true concern. That's a very legitimate concern for a parent to have. So commend her on, having that consideration that, she wants to be in a safe position that doesn't put her child in a place of influence that will or has the potential to harm his future. So hopefully all is well with Madam Walker and that she is able to find exactly what she was looking for. And it was such a sweet note to see the judge kind of not advise, but, skirt around advisement and just, give her perspective on the situation that Ms. Walker was facing. So here's the thing. She most likely would have lost because the law is most likely not in her favor. As a juror, or in a sense of a jury trial, individuals may have empathy for her, but their hands may very well be tied because there is no law that says that a landlord has to receive funds from DHS or any type of subsidized program, because it's a contract law. It's a contract that's between the landlord and the tenant. And so the third party, which maybe is DHS or whomever was paying on her behalf, is doing so at the benefit of the tenant. And then the landlord would accept that at the benefit of the tenant. but it's not a requirement. There's no law that says you have to. So the jury would most likely have jury instruction to know that the law does not require the landlord to accept those funds. And as long as the landlord gives the proper notice for vacating, they have the right to do so. It seems to be that the understanding and the reasoning behind their desire to terminate the lease is because they're not getting their funds in a timely fashion, though that the third party is making those payments, they're not doing so timely, and so the landlord doesn't want to be in this program anymore. It sounded great in the beginning because they were going to get their money, but they're not getting it in timely fashion, so it's no longer great for them. And Ms. Walker is not so happy with that because she doesn't feel like that's her fault, and it's not. She can't control the other entities' operations because they have the right to operate their business in the way that they can, whether they are understaffed and don't have enough staff to release the funds in a timely fashion, or they're holding the money so that they can have the interest rate off of the funds before they start making the payments. I don't know. Not sure. Or maybe that's just the way their accounting works. It just happens to be later than the landlord's agreement. They want on the 1st, no later than the 1st, and it's coming on the 6th, and they're not happy with it. Whatever the situation, I don't know the particulars. Unfortunately, the landlord has the right to terminate the lease, not even for a reason. Maybe that is not their reason. Maybe they don't want to keep tenancy with you, or they want someone else. They have a family member that's in need of the property, so they want to go ahead and allow the family member to stay. They want to move back because they can no longer afford their current domicile, whatever, right? They don't have to express the reason. They just have to make sure that they give you the appropriate notice. So what a cute way to leave off on the day. And we just hope that all will be well and that Miss Walker and her children, I believe she said more than one, I think it sounded like 3, but at the very least, the one that she was concerned for, the 18-year-old, are able to find a new home within a neighborhood that will be a blessing to them and without the influence that she's concerned for. All right, so we've learned some things. We've done YouTube things. We've watched, we've learned. So make sure you've done all that you should have done. If you didn't do it in the beginning of the stream, you did the liking. You did the sharing. You did the subscription. Guess what? That's the only clicks. Click, 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 click. Like, share, subscribe, okay? So don't need you to give any money, but just make sure you finish the night with doing the YouTube things. Like, share, and subscribe. All the best to you, Lyric Armstrong, your real estate agent and advocate.